Ever had that nagging thought, what if I get arrested? What can you actually do if you're just afraid it might happen, even before the police show up? Well, that's exactly what we're diving into today. We're going to demystify bail, which is one of your most fundamental legal rights, especially with the new Bharatiya Nagarik Suraksha Sanhita in place.
So let's jump straight to the heart of the matter. Can you get bail just because you have a hunch, a fear that you might be arrested? The answer is a huge, resounding yes, and you're about to find out exactly how that works. But first, before we get to the how, we need to get the basics down. Think of the bail system as a structure built on 4 key pillars. You really got to know these terms because they're the language of the entire legal process.
First up, there's bail itself. Now, this isn't some get-out-of-jail-free card. It's a proper legal process that lets someone get released from custody while their case is ongoing. It's all about making sure you're not locked up before you've actually been proven guilty of anything.
Next, we have the bond. You can think of this as your personal IOU to the court. It's a formal, written promise where you say, I swear I will show up for every single court date no matter what.
Then there's the surety. This is someone else, a guarantor, who basically co-signs your promise. They're telling the court, hey, I'll vouch for this person. I personally take responsibility for making sure they show up when you tell them to. They're putting their own credibility on the line for you.
And finally, we have security. This is the money part of the deal, a financial deposit you make to the court. It's the ultimate guarantee that you're going to stick to the promise you made in the bond. So all 4 of these things, they work together to create a system built on trust and accountability.
All right, so we've got our 4 pillars. Now, every single case starts at a fork in the road, and it all depends on the type of crime we're talking about. This is where things split in 2.
And here are those 2 paths. On one side, you've got your bailable offenses, which are usually less serious. For these, getting bail isn't something you ask for, it's your absolute right. But on the other side, you have non-bailable offenses, the more serious stuff. Here, bail isn't a guarantee, it's completely up to the judge.
So when a judge has to decide, what are they actually looking at? Well, it's a huge balancing act. The court is basically doing a risk assessment. They're weighing how serious the crime is against things like, is this person likely to run away? Could they mess with witnesses or evidence? They even look at personal things, like if the person is the only one earning for their family.
And that brings us to an incredibly powerful tool that's made specifically for those non-bailable situations. It's called anticipatory bail, and it's something you can do before an arrest even happens to protect yourself. Anticipatory bail is pretty much what it sounds like. If you have a real, reasonable fear and apprehension that you might get arrested for a serious, non-bailable crime, you can go to a higher court and ask for a protective order in advance. An order that says, look, if this person gets arrested, they must be released on bail.
So how do you get one? You have to file an application, either at the Court of Session or the High Court. After looking at your case, the court has a few options. They might reject your request, or they might grant you the full bail. Or, what often happens, they can give you a temporary or interim bail right away to protect you and then set a later date to hear the whole story.
Okay, let's tackle a really common misunderstanding. A lot of people think you need to have a formal police complaint, an FIR, filed against you before you can even think about asking for anticipatory bail. Is that true?
Nope, not at all. The answer is a clear and simple no. The law doesn't care about the paperwork at this stage. It does not require an FIR to be on the books for you to seek this protection. And this is the part you really need to remember. The only thing that matters, legally speaking, is your credible, reasonable fear of being arrested for a non-bailable crime. That feeling, that apprehension, is all you need to get the ball rolling.
So, what's the big deal about getting an anticipatory bail order? What does it actually do? Let me tell you, it is a complete game changer in a tough legal spot. Here's why.
Just imagine you're facing a potential non-bailable charge. Without this court order, your freedom is totally up in the air. It all comes down to what a judge decides in the heat of the moment when you get arrested.
But get that anticipatory bail order in your hands and the tables completely turn. That serious non-bailable offense, as far as your release is concerned, it basically gets transformed into a bailable one.
And this is the magic of it. What was once up to a judge's discretion now becomes your absolute right. If you get arrested, the police have no choice in the matter. They have to release you on bail. It's no longer a request, it's a requirement. And that brings us to the final, and maybe the most important point of all. Anticipatory bail does not stop you from being arrested. That formal process might still happen. What it protects you from is custody, from being held behind bars. It's a powerful shield that protects your liberty, letting you stay free while the whole legal drama unfolds.